Right, good morning, everyone, and welcome to episode 5 of the Tap HR podcast. Today, I'm going to be joined by Anna Bose, who's going to be covering some immigration law topics, which I think will be really useful for both HR professionals and small business owners. So, Anna is an immigration specialist. She's worked for the likes of KPMG and Deloitte, and also now runs her own firm. So, welcome to the podcast, Anna. It's lovely to have you.
Oh, thank you, Trish. It's lovely to meet you and your podcast listeners.
Fabulous stuff. So let's get cracking and get straight in. I've got some general questions that my clients have asked in the past and things that HR professionals have chatted to me about. So hopefully we can have a general chat, get through some of those questions and help some people out there.
Okay.
So first one is, what can you tell us about the new immigration rules that have been in the press a lot recently?
Well, I think the big thing to note is immigration law changes practically every day. So even though the press coverage may be quarterly or monthly, there are changes literally coming out on a daily basis, mainly because immigration law is based on statute and policy guidance, but a lot of it is guidance that the Home Office can change at their will and when they see as necessary. So what is law now may not be law in about a month's time. So it's a continually changing area of law. But the main changes that have affected the businesses, I would say, over the last 6-7 months is that main 4 areas. The Home Office no longer accept ignorance as a defence. So when you've got an employer who's done something quite innocently and the Home Office is bringing that to their attention, they cannot use the fact that they did not know what the law was. The Home Office are just very deaf to those kind of reasoning. Secondly, breaching sponsorship obligations or immigration laws such as right to work checks and things like that can lead to a black mark being against that company. So if they want to apply for a sponsor license, it may affect that. Or if they're on a sponsor license or hold one, they might find that they're being placed under special measures, or worse, that the sponsor license is revoked, which has serious consequences if they've got people, and normally it's quite high level people sponsored on their license. The third is that the burden has actually shifted considerably to demonstrate that you are meeting the immigration law and that you've got procedures and processes in place to ensure that you are compliant. So it's all the burden is on the employer. It's like the Home Office is saying, well, you've got the license now, you've got, you're employing them. It's not our fault that you've made a mistake or that you've done this or you've done that, which isn't quite fair when you look at the guidance, it looks very simple, but then it's quite complicated because one part relates to another guidance that's listed somewhere else, etc. And finally, many of the requirements of the immigration category have become quite subjective, such as you have to employ a genuine individual in a genuine vacancy. And what does genuine mean? How do you define what is genuine? One person's genuine is not another person's ingenuine. So it can be quite complex. So however, where you look at immigration law, it may appear very simple because you look at the websites and you see it tells you what to do and everything. But unfortunately, operationally, it's very complicated because if you make a mistake, you can find that you're being called off and you're not allowed to reapply for 6 months, which can have a huge effect on the business. So what I would always suggest is that get the advice. Get an advice from someone who actually knows and does and practices immigration on a regular basis. Someone who dabbles in immigration won't have the same knowledge on what the day-to-day changes are as someone who does it purely on a day-to-day basis. So just get the advice and you'll be fine.
And is there anything in particular that's prompted these changes? They sound quite specific around that kind of burden being on the employer. Has something happened to move that way?
I think it's to do with everything is staff shortages and costs.
Mm-hmm.
Before, Home Office would send out people to do checks. They still do those. They still carry out audits and do things like that. But they found that their actual sending people out to do those checks is quite time consuming and very costly because you're employing 2 people and most they can do is 3 or 4 checks a day. Whereas if you place the burden on the employer, Your checks are faster because you don't have to investigate as much, because ignorance is no longer a defense. So you can't say, I did not know. So if there is a blatant breach, you can just say, well, we'll just fine you and walk away. Or we'll take action and walk away. You don't have to investigate why that breach happened and things like that. And also the fines have increased a lot. So if they can gather some funds by fining employers, then that's what they're going to be doing, unfortunately. It's just the way of the world. I think it's happening in a lot of sectors at the moment.
So now that the burden's on employers, tell us a little bit more about what happens if someone realises that a visa isn't genuine. What should employers do if they find themselves in that situation?
Well, the first thing is to get appropriate advice. Unfortunately, immigration law and employment law doesn't always marry very neatly together. And there have been certain cases in recent months and years, most famously the one involving Asda, where if you dismiss somebody purely for an immigration reason, you still can attract unfair dismissal or constructive dismissal claims. So please get advice from both your immigration advisor and employment lawyer on how you approach that, rather than taking a snap judgment or decision. Because every situation will be different. It will depend on the type of visa, how is it not genuine, what other circumstances lead to that, that helps the employment lawyer to give the best advice as well.
That's really good advice. And what happens if you have somebody working for your organisation and their visa runs out? Is there a particular process that people need to go through? I suppose it links quite nicely to that previous question.
It does. And all of your questions have been great so far. So thanks, Trish. So basically, the right to work checks, which is part of immigration law, but also sits apart from immigration law in the sense that it doesn't sit in the Immigration Acts per se. The right to work legislation is very clear that if you have an individual, whether that is a non-settled person, i.e. that they don't have indefinite leave or citizenship, and that includes Europeans on pre-settled status, you have a legal obligation to track their visa. So there's a strict process that if you're tracking their visa 3 months before their visa expiry, you're meant to send them an email. It has to be written communication of some form that you can record and ask them, what is their intention? Are they intending to apply? What are they expecting to do? If you don't get a response, you're meant to keep on pestering them, in effect, on a regular basis until you get some sort of clarification exactly what they're doing. When they tell you what they're doing, if you're not sponsoring them, of course, if you're sponsoring them, that process is a lot easier because you're managing that process. But if you're not managing that process and they tell you we've applied for XY visa, you're meant to ask for written evidence and confirmation that that application has been submitted. In the UK, we have a very unique law in the sense that if you apply before your visa expires, your permission is automatically extended until that application is processed. So you continue on the same terms and conditions of your existing visa, even beyond expiry. But that's why it's absolutely imperative that the employer keeps a record that the application has been submitted. Then if the application has not been decided before the expiry date, then on the date of the expiry, they have to make an electronic submission to the Right to Work Checks Employers Helpline and obtain confirmation that the person can continue to work. Because uniquely, there's one category which rarely comes up, but there is one category that even if you do apply before the visa expires, you don't get that advantage of being able to continue to work. So you still have to have those backups. So if the Home Office comes to audit you on your right to work checks, you've got all the emails chasing the employee, and you've got the documentary evidence to show that you've done all the checks. If you've got all the documents, even if the employee has been fraudulent in any way, you're absolved because you've done what is required.
Okay. So a top tip there is make sure that you're on top of when visas are going to end well in advance, and that you've got all the evidence to show that you've chased it up to make sure that you're covered in that sense.
And if you do use software like PeopleSoft and other kind of Workday kind of HR software, They do have facilities to have an alert on your expiry date. I believe it does cost more, but it is worthwhile the investment if you think that a actual penalty for going beyond that is £20,000. It's worth it, basically, to just have that little embellishment on your software.
Definitely. And tell us a little bit more about students then. So are the rules for student visas very different to kind of standard visas? Not that there's a standard visa, but you know what I mean.
Yeah, of course. Most definitely there is a change, and most people who've been in HR or been employing people for some time have in their heads that students are allowed to work 20 hours part-time during term time and 40 hours during holidays, except that changed some years ago, and not all students have the right to work. So it depends what kind of course they're doing, how long the course is, and what their sponsorship is. So if someone is on a government sponsorship on their own country, then the chances are they don't have the right to work aspect written on their visa, and they're not allowed to work. So the best advice here is, one, have a copy of the visa, not just the biometric card, because sometimes it's not written on the biometric card, but have a copy of the visa and the biometric card, along with requesting a letter from the university themselves for confirmation that the person is allowed to work, because it is their obligation to inform you if you request it. And that way you have all the documents to confirm that the person is able to work.
Brilliant. Okay. And one of the things I get asked quite a lot is, what's the difference between a certificate of sponsorship and a visa? And do employers need to have both?
Well, you do need to have both. The best way of looking at it is a certificate of sponsorship is the instrument that enables you to apply for a visa. It doesn't on its own allow you to work in the UK. But similarly, some visas allow you to work without a certificate of sponsorship. But if you are on a skilled worker or a global mobility, or even a working holiday maker or some other kind of category, then you also need a certificate of sponsorship. You can't just have a visa, because your visa wouldn't get approved without a certificate of sponsorship. So sometimes you need both, but you can never work just with a certificate of sponsorship.
And how do employers go about being able to issue certificates of sponsorship? How does that work?
So the best way of looking at it is a sponsor license is a trusted relationship. The reason why it's trusted is because when you input any data onto the sponsor management system, it automatically is directly on the Home Office computer. So if you say someone's name is Trish rather than Patricia, it would literally show on the Home Office computer as Trish, and it won't accept it as Patricia. So the certificate of sponsorship is basically a page on a computer program that's on the Home Office portal. So the Home Office have portals that say the type of visa it is. So if it's working, the certificate of sponsorship will give the details of name, nationality, place of birth, type of job, salary, all those kind of details would automatically go on the Home Office computer. So when the individual is applying for a visa, they tap in the number that's associated with that individual, and all those details appear on their computer. So that's where the sponsor management system is basically, I don't know the technical term, an inroad or a kind of into the portal of the Home Office. And so basically that's what a certificate of sponsorship is. So you're actually just inputting a page or populating a page on the Home Office computer that says type of visa, and it's populating all the stuff. So you're doing the work for the immigration caseworker, in effect.
And what's the cost associated with all of this? So if I'm an employer and I want to start issuing certificates of sponsorship, how much is it going to cost me to start doing that? And how much does getting somebody a visa in general cost an employer?
So it can be quite expensive, but whether an employer has to take the full cost is debatable. So if we're looking at a simple 5-year visa for, say, a management consultant, you're looking at the employer having to pay £5,199 maximum. And that's for a 5-year visa. The £199 is towards the certificate of sponsorship. The £5,000 is a tax that automatically goes to the apprenticeship fund. It's called the immigration skills charge. So that's why that figure can only be borne by the employer. The other costs, such as the immigration health surcharge and the visa costs or priority processing, are all personal costs. So they are considered to be benefit in kind if the employer pays for it. I'm not a tax advisor, but just from working, as you said, I work for KPMG and Deloitte, so I have a good idea when my tax colleagues used to jump on me. And those are the kind of situations where you do need tax advice, whether you pay for it or is partially paid, or how is that orchestrated. That side of application costs, you're looking at circa another £4,000. So in general, you're really looking at close to nearly £10,000 per employee for a 5-year visa. It's a lot of money, but in an environment where you're looking at somebody and you're struggling to find somebody, the benefit sometimes outweighs the cost.
Mm-hmm. And tell us a little bit more about that. So a long time ago, when I used to issue certificates of sponsorship, we used to have to try and prove that we looked to find somebody from the UK market before we went out to find somebody who would potentially be on a visa. And earlier we were talking about kind of genuine vacancies as well.
Mm-hmm.
Still a thing, and how do employers go about proving they've got a genuine vacancy?
That is an absolute excellent question. And I love that question because the simple answer is, well, how long is a piece of string? You know, it's that $64 question. Essentially, genuineness is very subjective. So when the requirement is now that you have a genuine vacancy and the individual genuinely meets the requirements. So you don't have to advertise, but if you did or would have advertised, then you advertise. So what the Home Office is looking for is evidence to show that the person who you've employed genuinely does have the experience. You've tested and assessed that the person has the experience, skills and whatever to do the job, and he is the best candidate. Now, whether that is through advertising, that's fine. You don't have to, but if that's the best way of doing it, then that's great. If you've done it through, say, a business case, and a manager has put in a business case and it's been assessed by your kind of recruiters, etc., and you've agreed that's the way, and you just got all the documentation to show that process is in there, then that's fine too. I would say 99% of employers already have a very strict process for hiring and promoting people into roles in the UK. They wouldn't want to put somebody in just for the sake of it. Mm-hmm. You've got your odd ones where, and it rarely happens nowadays, where, say, a board member phones up and says, my nephew is the best thing since sliced bread. You've got to offer him a job and I'll invest so much money. Well, if it smells ingenuine, it's likely to be ingenuine as well for the Home Office as well. And that's the best way of looking at it, rather than to really beat yourself up over it. It's your processes, just follow them and make sure that you have all the documents in the personnel file, in their immigration section of their personnel file, that if they're ever audited, they can see your thought process on why you selected the person, how you worked out the person was the best person, and what the job that they're doing, they are suitable for that job. A good point to note here, and this is where a lot more people come up for scrutiny, is say you are a small company and you want to employ, I don't know, accounts payable person, and you see that accounts payable person's, the minimum salary is X amount, but you don't want to pay them that much. So you downgrade their job in order to get the certificate of sponsorship. So you pay them the lesser salary, but in effect, on a day-to-day basis, they're doing the higher salary job. In those cases, that's where the genuineness thing may come into play. So it's rarely going to be on the recruitment side. It's more going to be on whether you've got the right person with their skills and experience, as to whether you've got them or you're sponsoring them in the right job and they're doing that job. That's where the genuineness will come in.
Fabulous. And thinking about kind of that skills and experience piece, are there particular occupations that attract visas, or are there particular occupations that wouldn't attract a visa that people would need to be aware of?
Well, it depends on the immigration category. So you have your standard occupation classifications, or SOCs, as they're known, and they put a code next to a certain job, and some of those jobs meet the requirements of a skilled worker. Some of those jobs meet the requirements of a global mobility, and some of them meet requirements of, say, your interns, etc. So it depends on the type of visa you're going for as to what the job relates to. But there's also a lot of leeway. So, for instance, if you had an accountant, but you were employing a trainee, you would still use the occupation code for an accountant, even though they were a trainee. So yes, there's a lot of flexibility. You're really looking at jobs that are NVQ level 3 and above.
Okay.
If you're looking at skills criteria, which is why you can have gardeners sponsored, etc. There's certain relaxation of rules when it comes to nursing and care homes because of the health and care visas. But yeah, it's looking at the job rather than the job title. It's looking at the job activities and matching that to the ONS definition. So that's absolutely critical, because if you match your job title with an individual, but their activities relate to a different occupation code, you could lose your license because you sponsored them under the wrong code. So getting the right code is absolutely critical.
And you talked a little bit about cost, and obviously there's quite a large cost that goes with it, but hopefully there's a large reward because you get a skilled person.
Yeah.
Is there anything that the government does to help businesses in terms of those costs, or is it kind of all on the business?
Well, as I said, some of those costs are personal costs. Only the 5199 must be borne by the employer. If they're a small business, then they may not have to pay the £1,000 per year immigration skills charge. It can be reduced down to about, I think, 600 odd pounds. So it does go down quite considerably. Similarly, if they're a charity, it does go down. Also, certain jobs, if it's considered to be a shortage job, then the amount that the employer has to pay does go down.
Okay, fabulous. And what happens when things go wrong? So if I've got an employee, they're on a visa and actually things aren't working out and I want to let them go, how does that impact on their visa, and what do I need to do as an employer?
Well, as an employer, the first thing to do, as I mentioned, immigration and employment law do not always go hand in hand, is actually have a three-way conversation with your immigration advisor and employment lawyer to get your position clear on the employment side and then work on the immigration side. If that person is being sponsored by you, i.e. their visa is dependent on employment with you per se, then the moment you stop employing them and you report it on your certificate of sponsorship, that person will be sent a curtailment letter, and then they have a certain amount of time to either leave the country or apply. But so long as you've reported it and you've met your obligations, that's where your obligations end from an immigration perspective. If, on the other hand, they have a visa which is not dependent on employment, you have a lot more flexibility, because the only obligation you have is to let the Home Office know that you're no longer employing them. And, or if they have committed some sort of fraud, you've got to remember that the Home Office has placed this burden on employers. So it's not just reporting that they're not employed by you, but if, for instance, it's a gross misconduct because of something criminal has happened, then you are obliged to let the Home Office know, because that could have an effect on their visa and have a back effect on, if you didn't tell them and they got arrested, then, the Home Office can come to you and say, well, why didn't you let us know? Kind of thing. So it's every visa type would have a different effect on how you approach it and the steps you need to take in place. So just like when you want to get rid of something, you will have a protocol, you would have employment advice there. You just need to have a similar kind of, make sure your immigration policy, and most companies don't have an immigration policy, but to have an immigration policy that gives some sort of guidance to managers as to what they should be looking at, just like you would have a disciplinary policy, etc.
And are certificates of sponsorship kind of specific to an organisation? So if I want to employ someone and they've already had a certificate of sponsorship with their previous organisation, can they bring that with them, or do I have to put another one through?
Yeah, so certificate of sponsorship is particular to the job, the location, the salary, the activity, and the organization. To the extent that if you're an organization that has various branches, you can only issue a sponsor license should be per branch or per entity. It can't be an overriding. So if you look at a big company like Tesco, and Tesco has many kind of divisions within the Tesco bigger name, each division would have their own sponsor license. And so if that person was moving from division A to division B, you would have to obtain a new certificate of sponsorship. On the cost side, if, for instance, you sponsored for 5 years and that person moved to a different company or different division within your company within a year, you would get the refund of the immigration skills charge, not the 199, but the bigger bulk of it, you would get a refund back proportionately if that person moved to another company. But if you are hiring someone new who's already on a different company sponsorship, you just got to manage it really well so that their sponsorship doesn't end before yours begins, because you're not allowed to have more than 2 or 3 days in between sponsorship for that person to be considered illegal now.
And when employers are taking on a new person, if they're bringing family with them, is there any consideration that they need to make there, or is it the case that you're sponsoring the job and the role, and if someone's bringing their family with them, that's their responsibility?
In essence, it is their responsibility, but as we know, the market is, in favor of the individual because there's a lot less people out there. And in most cases, in my experience, employers want their employees to feel very happy. So they assist the family members because, as we all know, if you've got a spouse sitting at home and having to deal with additional admin that they didn't have to deal with, they're going to get it in one ear. And the last thing they're going to be concentrating on is on their job. So from a very kind of pastoral side of things, if you forget the family, you're most probably not going to have a happy employee. And if you are in competition, like some of my clients are for one individual, they're being chased by more than one company, you most probably find that company that gets them is the one that offers them the most assistance with the family. Yeah. From a cost perspective, obviously any cost incurred is a personal cost. So if you pay that cost up front, it is considered to be a benefit in kind. So again, they may be taxed on it. So that's a conversation you need to have. But because of the amount of money we're talking about, you're looking at thousands rather than hundreds. You may want to do it as a loan arrangement. A lot of people do. I've seen them do say, well, we will pay all the costs, but you have to stay with us for a certain amount of time. Otherwise, you'll have to pay it back. Those kind of arrangements are all above board and perfectly fine. The only portion that you're not allowed to negotiate is the certificate fee and the immigration skills surcharge.
Fabulous. So I think that's pretty much all of my questions, but is there anything that you would like to make our viewers and our listeners aware of? I know it's such a broad subject, so that's a very broad question.
Yeah.
Anything else that's relevant to go over?
I think the most important thing is sometimes immigration seems like a huge hurdle when you've got an employee. It is only a hurdle if you don't know what you're doing, or it's the ignorance of it that makes it the hurdle. There are a lot of ways and means of making it quite simple. Now, obviously, I would say is go to your immigration advisor, but it is literally that. I mean, it's a lot. Immigration is one of those subjects that it's very, very difficult to fix a problem that's already happened, because we haven't got a TARDIS. We can't go back in time and correct what you said to the Home Office. They do say, but you told us. So get the advice at the beginning, get fixed costs. It's not on most immigration advisors should not be charging you on hourly rates. So it shouldn't be, you're thinking of huge costs. They should be able to negotiate very well with you, like I do. I've got to think about the client. It's partnering and making sure that the advice and the policies make sense to the client, not the other way around. And it's also more important is live your life and make the immigration fit your life rather than the other way around, because you don't want to be always thinking, am I meeting my immigration requirements? That's a very tough thing to do.
Sounds stressful.
It can be.
How can people get in contact with you if they want to utilise your expertise? So obviously you've mentioned things like immigration policies and obviously that wealth of experience that you have with supporting your clients. How do they get hold of you if they want to use your services?
My email's the best way. My email address is anna@adbhadvisory.com. And of course, I will have a portal on my webpage as well, adbhadvisory.com. So to contact me that way, or through yourself, because it's great working together.
Fabulous stuff. Well, thank you so much for your time, and thank you for giving us that expertise. It's really, really, really useful. I have to do my standard disclaimer. So all information on this podcast is for guidance only. As Anna said repeatedly, it's a very broad subject, so make sure that you do take any legal advice if you need it. And if you want to see our podcast terms, head over to www.taphr.co.uk. Thanks so much, Anna.
Thank you, Trish.
See you soon.
Bye.
Bye.